Hey everyone, Dan McKenzie here with McKenzie Law Firm. We are a estate planning, estate administration, and small business counsel law firm in the Denver, Colorado area. And want to make a video today answering a question we get a lot is what, in a Colorado probate process, what rights do the beneficiaries have to make decisions, know what's going on, those kinds of things. As you may be aware, in a probate process, the court will appoint somebody to be the personal representative of the estate, and sometimes people refer to that as the executor. That is the person who's kind of the CEO of the whole process. They're the ones that kind of oversee the assets of the estate. They're the ones responsible for making sure they find the creditors, that they are protecting those assets, that they are making good decisions with the assets, protecting them while they're under their care for the benefit of the beneficiaries. They've got a lot of responsibilities, and so we get a lot of people in here, especially on the planning side, but also on the probate, when someone has passed away, who feel like, I really want to be the personal representative, or people who are planning are worried that if they pick one kid to be the personal representative, they'll offend the other kid or something like that. And I usually tell people, being the personal representative, it is a lot of work. It's a true job with true responsibilities and tasks that need to be completed and deadlines that need to be met. And the big thing that a lot of people overlook is liability that comes with it, right? So if you're the CEO of this whole thing, you do have responsibilities to make sure that things are done correctly, and you really can have, in certain circumstances, personal liability if you do things incorrectly. So being the personal representative is not all it's cracked up to be, to say the least. And like I say, I usually tell people, think twice before you really take that task on, because it's not nothing. But still, there are one of the big things, one of the big reasons a person wants to be the personal representative is there is some decision-making authority in there. So even a very common situation, of course, is that you've got an estate. The estate is going to be divided equally between kids, and within that instruction, the equal distribution, there's a lot of decisions that need to be made about, what we're doing with certain assets, who's getting certain personal property, is one person getting cash and another person getting real estate, how quickly is this going to be done? If we're selling a house, are we putting money into it first and taking our time to try and get the best price, or are we trying to sell it as quickly as we can, even if it just means taking a lower offer than we might otherwise get? All those kinds of decisions usually are in the personal representative's court, and sometimes we get people who come in and say, that the beneficiary of the estate and the personal representative is making these decisions and they don't agree with them, or they're not being consulted with, or things like that. And it's like, well, that's, why we have a personal representative, is to make those decisions. And the beneficiaries, the personal representative has to be fair. They have to put the beneficiaries' rights ahead of their own. They can't be doing stuff for their own advantage at the cost of the beneficiaries. So there are some pretty strong rules in place that do bind a personal representative. But at the same time, the beneficiary does not, they don't have the right to pick the realtor, for example. We hear that a lot. Like my sister went out and picked a realtor that I didn't like. Well, that was her job. She's the personal rep. So then the question arises, okay, well, what do I get to, what, as the beneficiary, what does happen here? What do I get to do? What rights do I have? Those kinds of things. So you have rights to information, and again, I've made other videos about this. There are two different probate processes in Colorado. There's the formal process and the informal process, and it matters, how you're going to get information. I mean, that's one of the primary purposes of having a formal process, is that it really requires proactive disclosures by the personal representative to the beneficiaries. If we're in the informal process, the beneficiaries still have the right to know all the same information, but they have to be more proactive about protecting their rights. So whatever happens, whichever process gets used, the beneficiaries are supposed to be notified near the beginning of the process. They receive a document called the Information of Appointment that lets them know that an estate has been opened, what county it's been opened in, what the case number is, and some other details about what rights they might have, and who the personal representative is, and whether there was a will, or those kinds of things. And so once you get that document in Colorado, I would say Most cases are done through the informal process, and what that means is the personal representative still has to create an estate inventory. They still have to put together an accounting. The beneficiaries still have a right to know what's in the estate and then what's going in and coming back out of the estate, and how they ended up with the final check that they got and those kinds of things. But the key thing to understand for the beneficiaries is that it's up to them to protect their own rights. And it really says that in the information appointment, that they have to, if the beneficiaries are unhappy with how things are going, they really need to let the court know. And even in a formal process, hearings get scheduled, but really those hearings are just deadlines by which a beneficiary needs to let the court know that they have a complaint about something. And so even in that circumstance, there's going to be a little bit more effort put into notifying the beneficiary through a very specific manner. But either way, the beneficiary in Colorado, the courts kind of assume that the personal representative is operating in good faith. And if they're not hearing anything from the beneficiaries or the creditors, they're kind of assuming everything's going fine. So if you're a beneficiary and you're thinking, well, the court is watching this and making sure everything is done right, that's not really true, to be honest with you. The court really isn't looking. There are certain filings they want to see happen, and one of those is that information of appointment. And there is a point at which the personal representative does have to confirm to the court that they did make the inventory available to the beneficiaries, that they did make the accounting available to the beneficiaries. But, the court's not really checking on those things to really make sure that they're true. They're taking the personal representative's word for it and relying on the beneficiaries to come in and let them know if it's not true. So the beneficiaries do have, you can't kick back and assume things are being done correctly. If you kind of have a feeling that things are taking too long, or assets are not being diligently managed and protected and all those kinds of things, you probably should look into it. Doesn't mean you should fire off an objection the moment, the first moment you get a suspicion, because that can unleash a process that can get pretty expensive pretty quickly. But you need to kind of stay aware and be aware that it's your responsibility to protect your rights. So if you're a beneficiary in a state, sometimes we help personal representatives administer estates. We also help beneficiaries make sure that their rights are being protected and that the process is being followed correctly. So if you're in that position and need some help, we're happy to talk. Again, we're the McKenzie Law Firm. We are in Denver, Colorado, and our phone number is 303-578-2745. And I hope this video was helpful. Thank you.